Today I'm talking about knives and offensive weapons. I say knives and offensive weapons because you can think of them differently, although a knife can, of course, be an offensive weapon. But first of all, if you're just joining our legal community and you've got questions of your own, make sure you like, comment, subscribe, and hit that bell icon so that you receive notifications of new videos. In an earlier video, I explained that it's an offence to be in possession of a blade or pointed article in a public place without good reason, unless, of course, it comes within that narrow exception of a folding pocket knife. So I wanted to talk a little bit more about what good reason is. There are several types of questions that have come up that I would like to address, but first of all, just stressing that this is not legal advice. This is just my views on the subject, and each case would depend on its own individual facts, which ultimately, if necessary, would be decided by a court. One of the common questions is going for a picnic and being in possession of knives, one of which could be a 12-inch long serrated bread knife, for example, used to cut loaves and make sandwiches. So quite obviously, if you were questioned for being in possession of a bladed article in that situation, your good reason is that you're out with your family or your friends or whomever for a picnic, and that's the reason that you have the knife with you. Now, whilst bearing in mind that the burden will be upon you to show that you have a good reason to have this knife with you, in the event that a prosecution were pursued in such a scenario where someone has a knife at a picnic or something like that, there is a two-stage test for Crown prosecutors that they must go through when deciding whether or not to prosecute. The first stage is the evidential stage, which won't trouble us in this particular scenario because let's just say that the facts are there. The person was in possession of a knife that contravenes the legislation in a public place. But what will be more interesting in this scenario is the second stage, which is the public interest stage. This provides that in every case where the evidential stage is satisfied, prosecutors must go on to consider whether a prosecution is in the public interest to proceed, and to consider whether or not an out-of-court disposal is more appropriate in the circumstances. When going through this stage, the prosecutor must address various questions to decide whether or not a prosecution is in the public interest. The first of those, which makes perfect sense, is how serious is the offence that has been committed. I'm sure you will agree that there's a huge difference between a person having a knife with their family and children in the park having a picnic to someone else having the exact same knife but walking around carrying it in the open in a shopping centre. Even if the person in the latter scenario is not directly threatening anybody with it, just having it in hand, in the open, in and of itself, is threatening to other people around, even though it's the same knife. So in these two examples, whilst the knife might be exactly the same knife, the seriousness of the offence is very different in each case. Similarly, the circumstances might be that you had a knife in a public place for a good reason, but then forgot about it. By itself, forgetfulness is not going to be a good enough reason, but in combination with other circumstances, for example, in one case where a parent had the knife but placed it in the glove box to keep it out of the way of children, then forgot about it, all of those circumstances considered together provided that it was a good reason that it was in a public place. Another consideration in the public interest stage for Crown prosecutors is the likely effect on the community. Now, by community, I don't just mean a community in a particular localized area, such as a village or a town or a city. A community could be a group of people that share similar backgrounds, characteristics, occupations, hobbies. The consideration would be, what impact does this prosecution have on this particular community of individuals? Is it a significant and disproportionately negative effect on the community that doesn't necessarily relate to a one-off incident? So as I've said in many of my videos, law is very often about common sense. If something makes sense to be restricted and prohibited, then it probably is. If another scenario just doesn't make sense to uphold a prosecution when most people would think that that's particularly unfair, unreasonable, or a disproportionate effect on the community such that it is not in the public interest, this is something that the Crown prosecutors should be considering. So in the situation where the police were to refer a case such as this to the CPS to consider for prosecution, and if the CPS were considering it for prosecution, representations could be made that it's not in the public interest to prosecute because it would affect such a wide community of people. Now, of course, each and every case turns on its own facts and circumstances, but in the situation where a prosecution was being considered for someone out camping, for example, or doing some kind of bushcraft where the knife was on their person for a very specific purpose, there would very likely be arguments in many cases like that a prosecution would not be in the public interest because it would affect such a wide camping and bushcraft community. So now we move on to offensive weapons, and quite quickly you'll be able to tell the difference between the discussion about knives and a good reason for possessing one and offensive weapons. Broadly speaking, there are three types of offensive weapons. The first of those is a weapon that is made to cause injury to another person. In other words, they are offensive in and of themselves. They don't have any other kind of purpose. Examples of these would be throwing stars, butterfly knives, hand claws, feet claws, belt buckle knives and push daggers, or any other kind of knife or object that is specifically made for the sole purpose of causing harm to another person. The second category of offensive weapons is a weapon that is not initially made to be offensive, but has been adapted to become offensive. A good example of this is a razor blade. A razor blade by itself is normally used for shaving, but if that razor blade is attached, let's say, to a stick, and its sole purpose is to be used to cause harm, this is an offensive weapon because it's been adapted to cause harm to another person. The third category is a very broad one. This is a weapon that is neither made nor adapted to cause injury, but it is the intent of the person that counts. Now this, as you can imagine, could incorporate almost anything. Let's take a hammer, for example. A hammer is just a tool. Whereas if a person takes a hammer outside with the sole intention of hurting someone with it in the street, it becomes an offensive weapon in the hands of that person because the intent behind it is to cause injury to another person. And this leads on to an area that trips a lot of people up. If you were to carry a hammer around with you in public for the sole reason for using it as a self-defense weapon, it becomes an offensive weapon because your intent was to cause harm to another person. The inference will be drawn, depending on the circumstances, that you had this hammer or whatever object with you for the sole purpose of causing injury to another person in those circumstances. And like many others, this is an area of law that's had lots of different interpretations. It may well be that the mere fact of a person carrying an object is not evidence of their intent to use it to cause harm, and it may be that the intention to frighten somebody with it is not in itself by enough, unless of course it is so menacing that it causes a person significant shock that can amount to an injury of a psychiatric nature. So I hope this short additional video has helped you to understand that whilst the laws in and of themselves can be very restrictive, a prosecution based on those laws must pass both the evidential stage and the public interest stage. And whilst there are many situations that have not yet been tested in court, these are the kinds of scenarios where representations could be made that a prosecution could have such a negative effect on a large community of people, and therefore that a prosecution is not in the public interest. Again, I'm sure there are lots more questions, and this is quickly turning into a series on knife law, so make sure you subscribe for the next one, and thank you for watching.